The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for court is now sitting. God save the United States and this honorable court.
Good morning. Good afternoon. Beg your pardon. We're happy to have you with us, and we're happy to hear argument in our first case, number 194496, United States versus Bartow. Counsel, whenever you're ready.
Thank you, and good afternoon, Your Honor, and may it please the court. Lieutenant Colonel Bartow was convicted under Virginia's abusive language statute for posing a series of rhetorical questions during an argument that mostly took place while Lieutenant Colonel Bartow was on his knees trying on boots. His conviction is contrary to both Virginia law and the First Amendment of the United States Constitution, and as such should be overturned for at least three related reasons. First, Lieutenant Colonel Bartow's mode of expression was rhetorical questioning, and therefore constituted protected speech and not fighting words. Punishing his rhetorical speech because he used an offensive word while posing his rhetorical questions is an unconstitutional viewpoint-based restriction on his speech and does not fall within the limited fighting words exception. Like a self-styled modern-day Socrates, he sought to challenge generally accepted norms through a series of rhetorical questions. At trial, the magistrate judge...
Well, counsel, if I could interrupt you.
Yes, sir.
Yeah, that's a generous description of your client, but I won't go there. If you before you talk about the merits, I'd like to understand what's the proper standard by which we review this appeal. I think your colleagues suggest we should defer to factual findings, and I think you've argued to the contrary. I think it's important for us to understand exactly what our standard of review is. Can you address that first, please?
Yes, Your Honor. And we would agree that there are some factual findings that you would apply a deferential standard of review towards. For example, what Lieutenant Colonel Bartow said, that he gestured, who he directed his words to. At trial, the magistrate judge found that he had directed the N-word towards one specific gentleman. I think that's a finding of fact, and I think a deferential standard is appropriate there. However, Your Honor, there's also a category of mixed questions of fact and law, and under Bose, those are more appropriately reviewed de novo. And
okay.
Those questions include both whenever there's a question of the legal effect of what he said, was the speech protected or was it not? That is a classic mixed question of fact and law, and that's entitled to de novo review, Your Honor.
I don't think Bose makes the distinction between mixed questions of fact and law and non-mixed questions of fact and law. It does say that some are, even though they're facts, you need judicial evaluation of them because they've been deemed to have constitutional significance. So I'm not so sure where that is, but I'm not sure it divides between mixed questions of fact and law and just facts. It seems to cover facts, special facts that have been deemed to have constitutional significance. That's what the Supreme Court said.
Yes, Your Honor, I would agree with that. And in a Justice O'Connor concurrence, she pointed to whether or not words were fighting words is a classic example of that, though I grant you that that's somewhat vague guidance. And at trial, the magistrate judge characterized some of Lieutenant Colonel Bartow's speech as bizarre.
Okay, I have a question about your opening layout there. You categorize all this as merely rhetorical questions by a modern-day Socrates. is it the case then that as long as you frame whatever you're saying in the form of a question, it can never amount to fighting words?
Your Honor, we would not take that position. I think we would concede that you could frame a rhetorical question where it had no value other than to be directly insulting or abusive to the person to whom it's addressed. So, for example, Your Honor, if I was speaking to somebody and I said, "What are you, some sort of idiot?" then there's no other expressive value.
Do you think idiot is less of a fighting word than the N-word?
Well, Your Honor, I think the specific word I chose was less a point than the direct insult. But no, I do not. I think, in fact, in this case, I think the offensiveness of the N-word was central to the point Lieutenant Colonel Bartow was trying to convey, which was that to him, the use of sir and ma'am, which are...
Yes, but I understand your argument about the sir and the ma'am, but it appears that he came in there almost looking for a fight, because he didn't bring up the thing about the sir or ma'am until his second salvo. In response to good morning, he went off with a rhetorical question.
That's right, Your Honor. He's certainly an expressive individual. I don't think he was trying to pick a fight, and at trial, the magistrate judge characterized that rhetorical question, which the testimony was a little bit uncertain on the exact words, but I think it was.
What about the fact that he wasn't, I mean, we can, looking at everything that happened here, I know you said that he was, for the most part, sitting down trying on boots, but he wasn't always sitting down trying on boots. He stood up, he pointed at people, he got aggressive and close with the other people in the store. What about that?
Well, Your Honor, a few points. I think, first of all, using gestures, being animated is completely acceptable, and we would concede that it was a heated conversation. In fact, he did believe that he was being harassed. And I think the video record shows, Your Honor, that the white male lieutenant colonel, who was the first intervener in the conversation, his body language was much more animated, much more threatening than anything that Lieutenant Colonel Bartow ever did.
What counsel? What would give me an example of what would constitute fighting words in your view?
Your Honor, in footnote 2 of our reply brief, we cited a number of examples from the cases the government cited. I think,
and you take the position that those are, in that footnote, those are appropriate examples of fighting words?
Yes, Your Honor. This is not a facial challenge to the statute as limited by Mercer v. Winston, which is the Virginia Supreme Court case that held that the statute is limited to words that have the direct tendency to cause acts of violence by a person to whom individually the remark has been addressed. So, Your Honor, to point to a case, Cohen v. California, the case with the jacket that said, "Fuck the draft."
Right.
That would not be a fighting word, but if you were in the middle of a heated conversation to point your finger at somebody in jury or by a judge at trial to be a fighting word, Your Honor.
But all those examples in footnote 2 in your reply brief include the N-word. So I'm confused.
Yes, Your Honor, and certainly we wouldn't say that there's never a context where the N-word could be a fighting word.
Well, the presence of the N-word is what makes this case complicated, right?
I agree.
I doubt there would be an attempt to find a crime had been committed. So you have to deal with that.
I agree. I agree with you, Your Honor. And I think there's no question that the N-word was offensive in that context, even though I think Lieutenant Colonel Bartow did not intend for it to be understood offensively. His intent was in conveying how offensive he found the word "sir" to be. So to say that something is analogous is not to intend to offend.
Well, the government says, let me ask you if you agree with this. The key question thus becomes whether the N-word was specifically directed at an individual in circumstances where violence could result and was likely to do so. Would you agree with that? That's the key question in this case.
Your Honor, I would not agree with that.
All right, what do you disagree with?
So first of all, I think that it's important to go back to the magistrate's finding that the word was directed at the second intervener, who is an African.
No. My question, I guess, has not been clear.
Okay.
The key question here, not that it's been resolved against you, but the key question is whether the N-word was specifically directed in an individual in circumstances where violence could result and was likely to do so. That's the question that has to be resolved.
Your Honor, I would agree with that, except I would add that the N-word would have to be used in a way that was intended to be insulting or abusive, and not in a way that was intending to convey a non-fighting words expressive.
Well, it seems to me that's such a big, tell me an example where it would be specifically directed at an individual in circumstances where violence could result and was likely to do so and would not be regarded as fighting words.
Your Honor, I think that to take an example perhaps of a white rapper who used the N-word as part of a song and used it.
Now he has to specifically direct it at an individual in circumstances where violence could result and was likely to do so.
Yes, Your Honor, but I think if the intent there is not to insult, but is to make a protected point, then even if it could stir the audience or could stir the person it's being directed at to violence, it's still protected speech, Your Honor.
I don't get where you come up with his intent matters.
Right. Don't the words speak for themselves, so to speak?
So, Your Honor, I do think that the offensive nature of the word speaks for itself, yes. But to address Judge Thacker's question, whether intent matters, I think there's a few points. First, I would point to the Supreme Court's decision in Ilanis, where they determined that there was...
If you could speak up a little bit, please. I'm having trouble hearing you.
Yes, Your Honor. I'm sorry about that. First,
you were about to point to Ilanis, and Ilanis said itself that it's not necessary in that case to consider any First Amendment issue. So Ilanis didn't consider the First Amendment. So what's your next point?
Your Honor, I still think that is a basic principle of criminal law, that one has to intend the wrongful conduct. And here, what makes the use of any word wrongful is the offensive, the direct insult or abuse that could result in violence. But second, Your Honor, I think that there's a distinction between fighting words and threats, where subversive speech is inherently likely to cause a violent reaction in an audience. If somebody is making an unpopular point, they might, and in this case, I think there's no question that Lieutenant Colonel Bartow is making an unpopular point. They might stir their audience, they might stir the person they're talking to violence, but unless that is their intent, it has to be protected speech, Your Honor. Mm-hmm. Otherwise,
well, in the Supreme Court case of Chablinski and Johnson, the inquiry is objective, not subjective. Subjective intent doesn't matter. And the Virginia Supreme Court said the same in Mercer.
Your Honor, I think in those cases, there was no question what the speaker's intent was. In Chaplinsky, where he said, you're a goddamned racketeer and a fascist, he's directing the speech towards the addressee, and there's no other rhetorical point being made other than to insult and to abuse the target of the speech.
But yeah, counsel, and maybe I'm just belaboring what Judge Motz and Judge Thacker have said. I mean, we don't have tons of law on this, but I don't think any, Chaplinsky, Cohen, RAV, all the handful of cases we have, talk about it being likely to incite the average person to breach the peace. And it seems to me like you're adding an additional inquiry we need to make about what was in the mind of the speaker at the time. And I don't recall seeing that in any of those cases.
Well, Your Honor, I don't think it was an issue in any of those cases. The speech in all of those cases was unambiguous, and I don't think the government has pointed to any cases where there is this question of whether somebody's being punished for rhetorical speech or whether it's simply to assault, to abuse, denigrate, insult to such a degree that it's likely to lead to violence.
All right, I guess your time has expired. Perhaps you've reserved some time for rebuttal.
Yes, Your Honor, if I could reserve my remaining time. Thank you.
So we'll hear from the other side now.
Good afternoon, Your Honors. May it please the court. For almost 80 years, the Supreme Court's decision in Chaplinsky has stood for the proposition that someone cannot escalate a confrontation using abusive language to the very threshold of violence and escape potential prosecution for breach of the peace. To paraphrase the district court, this defendant used a racial slur laden with historical invective as the final thrust in a vulgar and heated confrontation. His prosecution for that wrongdoing was constitutional.
Is that single word sufficient to incite a fight, to be fighting words?
No, Your Honor. The overwhelming
So when does it cross the line?
It's always a totality analysis, and the cases in this area always look to both the circumstances and whether or not the slur or word itself is abusive. Here, I don't take my friend on the other side to contest that the slur constitutes abusive language. So then that leads to the circumstances. And as I parse out the record, Judge Motz, there are 7 circumstances here that support the magistrate judge's factual finding. First, the defendant opened this interaction with Ms. Johnson-Felder with aggressive, vulgar questions. Second,
well, I think that that's not so clear. They were very odd questions. It seems like this guy has some mental problems, or at least a very odd personality.
I understand, Your Honor. I do think the second factor here is the magistrate judge made a factual finding, we think supportably, that the gestures here were threatening. They included hands on his hips, followed by pointing at the store clerk directly from only a few feet away. There's volume. Ms. Johnson.
Do you really think that threatening to Ms. Johnson-Felder or threatening to anybody? I mean, I've watched that videotape a number of times, as I'm sure you have, but and lots of it repulses me. But I have a little concern that you're saying putting hands on your hips and doing the hand gestures he did creates a threat. I mean, quite frankly, I better not go home at night because I get that a lot at my house, and I don't think that's I've never taken it that way.
I totally understand, Judge Quattlebaum, and I want to be really clear. My argument is not that any of the things I'm trying to tick through in isolation would suffice. My argument, and perhaps this goes to your initial question, Your Honor, you asked about the standard of review. So
yes, sir.
In our view, because we think this is simultaneously an as-applied challenge and, in effect, a Rule 29 challenge, because the Virginia Supreme Court in Mercer collapsed the statute to a Chaplinsky inquiry, We think that the standard of review here is deferential twice over. There's clear error review of the magistrate judge's factual findings. And there's the additional fact that under Rule 29, we draw all reasonable inferences in favor of the magistrate court's judgment. And so, to be clear, when I am ticking through these factors, I affirmatively am disclaiming that any of them in isolation are enough. What I am trying to do is saying that in a Rule 29 posture, where the question is, did the magistrate judge clearly err in concluding that this language was abusive and not rhetorical, and directed at both Ms. Johnson-Felder and the African-American civilian bystander? Is that in any way clear error? And our assumption is no.
Having said all that, do you think that standard of review is any different than what the Supreme Court said in Bose?
I do not, Your Honor. I think the Bose standard is perfectly fine. But I would point out—
Judicial evaluation of special facts that have been deemed to have considered significant. We must conduct an independent examination of the allegedly unprotected material.
I agree with that.
That's what we're supposed to do, an
I agree.
independent examination.
But I would say, Judge Motz, there's a paragraph that caught my eye as I was rereading Bose that I think is helpful here, which is there's a section where the Supreme Court says, to the extent that there is clear error review of factual finding that bears on that de novo analysis, oral testimony receives even more deference than documentary evidence. And I think here that matters. One of the salient features of this record is that the only evidence about this slur came from the testimony of Ms. Johnson-Felder. She testified to it 3 times at JA 18, 23, and 33. And I think it is reasonable to believe that when she said what the defendant said to her and the African-American civilian, she might have did so with a tone and a timbre and an emphasis that Magistrate Judge Buchanan heard, and that very well have borne on her conclusion that what happened here was abusive and not rhetorical.
Do you have a transcript? Did you hear her tone of her voice?
No.
Is that what you're saying to me?
No, I'm saying that under Bose Corporation, when there's clear error review attendant to oral testimony, it is especially deferential. That's the only thing I'm saying, Your Honor.
Counsel,
okay.
I'm sorry, go ahead, Judge Thacker.
No.
So, Counsel, let me, as I understand what we're trying to look at is whether the average person would be incited to retaliate in a way that breaches the peace. And I realize it's not a individual, how any one individual would react as we look at that. But does it matter at all that none of the people in the vicinity here retaliated in a way that breached the peace? Does that matter at all?
My answer, Your Honor, is that while I think it is some evidence in the defendant's favor, it is not dispositive and it's not a complete defense. Just as on the other side of
No, but it is. There were half a dozen people. That was going to be my question, too. And none of them seemed to react at all.
That's correct. Although I think on the other side of the spectrum.
Well, how soon did the security guards show up?
Judge Thacker, my reading of the video, we know that the slur is used between the time the uniformed captain and the African-American civilian arrive on the scene and the time Miss Vicky Helder arrived on the scene as the security guard. My reading is that that is between 3 minutes and 3.5 minutes into the interaction. So fairly soon in the 8-minute video.
Yeah, but enough time for people to be alarmed and scared.
That's correct. And Judge Motz, actually to your point about how nobody sort of on the video seems to visibly react, I would say 2 things.
Actually, it was Judge Quattlebaum's point, but go ahead.
I would say 2 things. One is Miss Johnson-Felder was very clear that the use of the slur is what prompted her to call for security. So she believed that that slur escalated the situation to the point where she wanted intervention. And the second,
let me just think, because I think the test is whether it would incite the recipient of the speech to retaliate in a way that would breach the peace. So I'm having trouble how you are saying that her response, which is admirable, is consistent with the standard you have to meet. I mean, what here's someone who was no doubt insulted, as well she should be, and rather than go up and slap him, which, you know, might have been understandable too, she called security. I mean, how does that help you?
Let me try to do this in a sentence, Judge Quattlebaum. I think what people did in the room at the time, up to and potentially even after the slur is used, is relevant to the totality analysis of whether or not the Mercer-Chaplinsky test is satisfied. But at the same time, just because nobody hauled off and punched the defendant in the face, that is not a complete defense under Chaplinsky, because as the court was saying a moment ago, it is an objective standard. I'm just saying it's relevant, and it's relevant on both sides. I'm not saying that it's dispositive here.
And is she required to actually respond and rise to the incitement in
Absolutely
order
not.
for it to be fighting words? I mean, she was in a situation where it could have been dangerous. This person did seem to have some challenges, the appellant, I mean, so it could have been dangerous for her to rise to that occasion in any way other than she did.
I agree. There's absolutely no requirement that any of the people here had to rise to the level.
You had 7, Mr. Young, I think you said you had 7 points you wanted to make in the totality of the circumstances, and I heard maybe 2. I'd like to, if you could quickly do it, maybe run through the 7.
Absolutely. 1, aggressive vulgar questions. 2, threatening gestures as found by the magistrate judge. 3, volume. Ms. Johnson-Felder said that he raised his voice, was yelling, and everyone heard him. 4, the fact that his conduct drew a crowd, including the lieutenant colonel, who himself escalated the situation by stepping towards him and putting his finger in his face. 5, the defendant's rejection of de-escalation efforts. When the African-American civilian and the uniformed captain arrive on the scene, they both try to calm things down, and the defendant's words are, "I'm not going anywhere." 6, the fact that, and this goes back to my dialogue with Judge Quattlebaum about it's evidence, but it's not dispositive, the fact that immediately upon hearing the slur, Ms. Johnson-Felder went for security because she believed security's intervention was necessary. And then 7, I do think it's relevant that the tension level remains high even after the slur is used, because I think it is evidence of what was happening at the moment the slur was used. So I think it is relevant that a few minutes later, the lieutenant colonel has to be physically separated by the security guard from the defendant.
I appreciate how quickly you did that. Tick through the 7. What about the fact, in terms of the totality of the circumstances, that he did continue to try on the boots? He was sitting down some of the time, standing up some of the time, but he continued to carry on his business trying on the boots. What about that?
I think it's relevant, but I don't think it leads to the conclusion that the magistrate court committed clear error. And I would phrase this in terms of Chaplinsky itself. So Chaplinsky favorably quotes the New Hampshire State Court, which said, look, if Chaplinsky had said racketeer and fascist, but he had done so with a disarming smile, no constitutionally permissible prosecution. So on our view, if at some point Mr. Bartow had sort of disengaged, stepped back, lowered the temperature and said, I am not trying to provoke a confrontation, I simply have a political view, that would be 100% constitutionally protected. But on our reading of the record, Judge Thacker, even as he is on one knee trying on his boot, I mean, that's the posture in which he uses the slur, which the magistrate court was concluded was directed at both the civilian and at Ms. Johnson-Felder simultaneously in an abusive fashion.
But don't we have to determine whether a reasonable person would react with violence to a person ranting in a school, in a shoe store, on a Marine base? Isn't that part of our determination here? And it just none of those things. We have the tape. We don't have to listen to somebody's characterization of it. Isn't that our position? No matter what findings were made, that is entrusted to us.
I agree that it is a totality analysis, and I agree that the setting is relevant. All the cases say the setting is relevant. I suppose
we're ultimately looking to see if a reasonable person would react with violence.
I agree. I agree. And the government submission in the district court on the first round of appeal, this appears at JA 123, was that any of these three people could have been provoked to breach the peace. And I would tie this answer to the text of the Virginia statute, because we actually charged two different prongs in the criminal information. One prong is about cursing or abusing someone under circumstances reasonably calculated to provoke a breach of the peace. I think in light of the magistrate judge's findings, we satisfy that as to the African-American civilian Antimus Johnson Felder. The last prong is using violent, abusive language under circumstances reasonably calculated to provoke a breach of the peace. And as we argued to the district court, I think that applies to the lieutenant colonel. The lieutenant colonel intervened here to protect the African-American store clerk from an increasingly hostile and potentially violent situation. And by deploying the slur in the way that he did, the defendant in effect sabotaged the lieutenant colonel's efforts to de-escalate the situation and protect the victim. And on those facts, we think it's also reasonable to believe that he might have reacted with violence given all the circumstances.
Yeah, but counsel, you keep using like he might have or he could have, and I grant you that all day long. But what you're required to show it is that it is likely, which is more probable than not, that someone will breach the peace, which is another way of saying break the law. So it seems to me that's a pretty high standard, and I guess it is because we're talking about the First Amendment. And so when you kind of, in your responses, lower the standard, probably not intentionally, I know this is, I don't mean to play gotcha with that, but use words like could or might, I think that's not what we're supposed to be looking at.
Judge Quattlebaum, you are 100% correct, and I apologize for the imprecision. I think the question is, in light of all the circumstances, could the defendant's face-to-face abusive and insulting language likely provoke violent reaction or retaliation from any of the three people I mentioned? I'm quoting that directly from Mercer. That is correct. That is the question. I agree completely.
Do you have anything further?
I suppose, Your Honor, I would simply end here.
You don't have to. I had a colleague when I first joined the court who would always say, you don't have to use all your time.
Well,
a South Carolinian.
Understood.
Ahead,
I suppose I would just end here. The Mercer inquiry that we just discussed is always going to hinge on a conjunction of the circumstances and the actual abusive language that is used. And I think it is appropriate to end with Judge Ellis's observations, which are in conformity with then Judge Kavanaugh's observations on the DC Circuit. This word carries more invective force than practically any other word in the English language. In RAV, Justice Scalia analogizes the fighting words doctrine to running an overly loud loudspeaker truck, which is why it's not content-based. It's a form of mode of expression. This word cranks up the volume to 11 and took a dicey situation and converted it to one where, satisfying Mercer, it was reasonably likely that violence could have ensued. And for that reason, we ask the court to affirm the judgment.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. I'd like to say a few things in response. First, we are not contesting the record, what is in the testimony. So, well, I agree that there are circumstances where in-person testimony is entitled to greater weight. We're not contesting what was said. And in fact, I would point to JA-18, where Ms. Felder is describing the situation leading up to Lieutenant Colonel Bartow's use of the N-word. She says, then another African-American gentleman came into the picture and in a calm voice trying to say, sir, the reason that she said sir or ma'am is because you are purchasing merchandise at a military installation. and there is a common courtesy associates say sir or ma'am to their customers. And then at that moment, he responds by saying, if I called her an N-word, would she still say good morning? And Your Honor, I think that exchange is the key to understanding what he was saying. And I think it's also the key to understanding that this didn't escalate the situation. This was meant to try to put into his words to communicate just how strongly he felt. And Your Honor, I would submit that there's no First Amendment requirement that a speaker not be offensive or that a speaker be effective in communicating or conveying their message. He was struggling to convey just how strongly he felt about the word. And that is, that leads me to the next point I'd want to make, which is that, well, the magistrate judge found that his speech generally was directed at a number of different people. At the top of JA 52, she found that the N-word specifically was directed at that gentleman, that African-American intervener, and not at Ms. Felder. But what Mercer requires, Your Honors, is that the statute be limited to words having the direct tendency to cause acts of violence by a person to whom individually the remark has been addressed. So I completely disagree with the government that for example, the white lieutenant colonel's clear anger in the video is relevant to the inquiry here. And I think the question that was not answered at trial is not whether any of the bystanders would have been justified in throwing a punch after he said that, but whether the specific gentleman to whom he directed his words would have been justified or would have been reasonably likely to respond with violence.
I'm sorry, and I missed that. To whom do you think he directed these words? And I meant to ask your colleague that, but
I think the testimony at the bottom of JA 18 and the top of JA 19 makes it clear that the word is being directed in response to a question from the African-American intervener, who's trying to explain why she was using the words sir and ma'am. So even at the point where the second intervener comes into the picture, it's clear that that's what he's upset about. I disagree that there's any confusion. He is perhaps ranting, but he is ranting about being addressed as sir.
But I mean, he did get upset at good morning.
right?
Yes, Your Honor. I think he got.
Didn't use the N-word.
Right. I think that's correct. None of the words he used, and the magistrate judge didn't find that any of his speech in that context was would have come close to falling within the fighting words exception, Your Honor. Barring any further questions, Your Honors, I would say that speech is protected and does not fall within the narrow fighting words exception to the First Amendment unless it is intended to abuse, degrade, or insult the person to whom it is directed, and a reasonable person standing in that person's shoes would be likely to respond with violence. And Your Honor, given the record, given the facts here, the evidence wasn't sufficient to show that, and in fact, the evidence was sufficient to show that he was engaging in constitutionally protected speech. Therefore, his conviction cannot stand.
So just let me give you a hypothetical. You are in a room full of African Americans, and there are 2 or 3 white people, and one of them says to the other, "You're just a no good N-word." No fighting words, right?
Well, Your Honor, I don't know that there's expressive value there, but I think that that's terminolo. That's making an unpopular point to perhaps a room where there is some potential for violence.
But my point was it wasn't directed at
Correct.
the African Americans. It's directed at a white person. And I thought that in and of itself, you were suggesting meant that it couldn't be fighting words.
Well, Your Honor, I think it would depend on how the word was being used to the white person. I don't think that you could never find that the N-word directed at a white person was a fighting word, but without more, then I would agree.
Okay, you're as bad as the N-word?
Your Honor,
I mean, I don't understand what you give me an example where it would and wouldn't be then. Fighting words if directed at a white person.
where it would be, Your Honor?
Where it would be and where it would not be.
Yes, Your Honor. In the context of, say, those two white people are having a heated dispute, and the person says there's plenty of language in the cases the government cites, you're just a effing N-word, then that perhaps could be an example of a fighting word, but it would depend on the addressee's reasonable reaction and not on the crowds, even if people were likely to overhear that exchange.
Okay. Thank you very much. We will take the case under advisement, appreciate your arguments, and go directly to our next case.
Thank you, Your Honors.
Good afternoon.
We're happy to hear argument in our second case, number 166843, Holcomb versus Ravenel.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Nelson Chandler, and I represent the defendant appellant in this case, Ms. Tamara Ravenel. So this case has a tendency to focus largely on institutional policy and procedure of SCDC, or the South Carolina Department of Corrections. It's important to note at the outset that the procedural due process claim at issue in this matter is one for monetary relief against my client in her personal or individual capacity. And at the time at issue, my client was a classification caseworker at Lieber Correctional Institution. And that was in April of 2016 when she chaired the committee that recommended the assignment of the plaintiff to security detention status. And we're here today before this court on de novo review on the issue of whether my client, Ms. Ravenel, is entitled to qualified immunity because either A, the undisputed facts do not demonstrate a violation of the minimal level of process established by Hewitt versus Helms in 1983 for security detention, as opposed to disciplinary detention reviews. Or in other words, because the plaintiff cannot show a violation of the due process clause of the Constitution. Or we're entitled to qualified immunity because the plaintiff cannot demonstrate that the particularized right that he claims was or is clearly established in a way that would have put this issue beyond debate and rendered it plain to Ms. Ravenel that her actions somehow violated the law. And in fact, nothing could be further from the truth here because Mrs. Ravenel, who is not a executive level policy maker, but a classification caseworker who follows policy, was acting at the time at issue under what was then a new policy that had been specifically amended to address certain legal claims and decisions, specifically including the 2015 opinion of this court in Nkuma. And I understand two members of the panel.
Go ahead, Judge Caldwell.
So, Mr. Chairman, I want to make sure I understand there. I understand the analysis, and we'll hear about that, I'm sure, coming up about how the process that was provided here relates to Hewitt. But I want to make sure I understand the perspective you're asking us to look at. Are you suggesting we should do something other than compare the process provided to Hewitt, or are you saying that in addition to that, we're supposed to look at it from the perspective of your client and her particular position there at the center?
Well, yeah, Your Honor, that's a good question. I think that answer might depend on which prong of the qualified immunity analysis.
Assume we're looking at the second part, not whether there's a violation, but whether it's clearly established.
Okay, Your Honor, if we're looking at the clearly established prong, I think the question then is to first identify the right that's being claimed with an appropriate level of specificity, and then see whether that right is so clearly established that a reasonable officer in my client's position would have been plain to somebody in my client's position that she was acting in violation of the law. Does that answer your question?
Yeah, it sounds like you're. Yeah, I think I do. All right, I appreciate it. Go ahead.
Your Honor, we would respectfully submit that the district court erred in two different respects, either of which is sufficient for reversal. First, on the first prong of qualified immunity, the district court did not evaluate the alleged due process violation under the Matthews versus Eldridge standard, which this court has said most recently in the Williamson case in 2018 must be done. And the Williamson case uses that mandatory language. If you're going to evaluate a procedural due process violation, you must apply the Matthews versus Eldridge standards to the claim. Both parties in this case, Your Honor, thoroughly briefed the Matthews test, and it is our contention that the application of the Matthews factors to this case indicates that plaintiff was plainly afforded basic due process. All right, that's the first.
And how are you defining the right to due process here that you say he was afforded?
Okay, Your Honor. On the first, as far as the first prong of the analysis is concerned, where we actually determine what extent of the law is, I don't think we need to create any new terminology, as perhaps the district court did, but simply look to the right as it has been defined by the Supreme Court and then more recently by this court. And so I think if you look at Hewitt versus Helms, which is certainly the seminal case in the Supreme Court.
So what is the due process right that you're talking about? Is it fair notice?
No, Your Honor. The right is, as defined in Hewitt, is some notice of the charges. Some notice of the charges.
So what notice did he get?
Okay, that's a great question, Your Honor. And we contend that if you look at the record, it's uncontrovertible that the plaintiff had notice. And the charge is not a perfect term here because there were no new charges against the plaintiff in this case. This is not a disciplinary determination, right. This is a security determination. So
where shall I look in the record to see that it's uncontroverted that he had notice of this hearing before he showed up to the hearing?
Your Honor, to answer your question, we don't contend that he had notice of the security detention review. We do not contend that. That's
okay. Well, isn't that? I thought that was the problem here, or the challenge here.
That is the challenge, Your Honor. The plaintiff says he had a right to know when the SD board would convene. And our position is his right was not to know when the board would convene. His right is to notice of the reason he is being placed in security detention and that he have some opportunity to address that reason. And that's the description.
Doesn't he need to have fair opportunity to address that reason?
Certainly would not dispute that, Your Honor. And we
okay.
believe
Go ahead. How did he have fair opportunity to address it?
Well, Your Honor, when he was, to back up a bit, this all originates from a March the 23rd search and seizure of his, or search of his cell.
Right, where they found all that contraband.
Right, so several days later, he received notice that those charges would be brought against him. 2 weeks later, he received a full disciplinary hearing with full due process as required
on April 14th, and then April 18th was the hearing to change his security status.
Correct,
so when did he get notice of the April 18th hearing to change his security status?
Once he arrived at that hearing, Your Honor, that's not that is not an issue that is a fact in dispute in this case. But the point here, we believe, is that the type of review that was in place is supposed to be an informal, non-adversarial process. And it may satisfy due process for that hearing to have gone forward without his presence. As long
Counsel,
as,
could I, my question really relates, does the record help with this question? Are the factors that are being considered at the hearing that is the subject of the complaint here, where he didn't receive advance notice, are I think I'm saying something you agree with, right? He didn't get advance notice of that hearing. But is the subject matter of that hearing or the reasons for the detention in that hearing the same reasons that were the subject of the prior disciplinary hearing?
Yes.
And if so, does that matter?
Yes, Your Honor. We think it certainly, I don't know that it's necessary, but it certainly bolsters our position in this case.
Well, it is necessary, isn't it? I mean, I would think it would be critical to your case.
Well, Your Honor,
if he didn't have prior notice of something of the underlying charges, then he would have had no notice.
True, Your Honor. If he had to at least know, he has to have known the purpose for which he's being placed on security detention, which he did. Right. And
I thought your point, counsel, was, and you know, that as long as he got notice at the hearing, that it's not clearly established you're entitled to advance notice, but that prior hearing nevertheless is some notice. I may be misunderstanding your position. If you could just clarify what it is, so we'll be better able to decide.
Right, Your Honor. And one point that might help illustrate that is...
Well, could you just answer Judge Quattlebaum's question? Because I think that was a good clarification. Which is your argument? That he had prior notice and that was sufficient, or that he had prior notice and he got notice at the beginning of the second hearing?
Well, it is critical that he knew of the reason he's on security detention, and that reason originated from the disciplinary hearing several days before. Now, I'm trying to separate out notice of when a review is going to take place and notice of the subject matter for which they're being held in security detention. And the notice that the Constitution requires is notice of the reason for your detainment. It didn't matter if they had that security detention review a day before or a day after. And it didn't matter if he knew where he was going. It matters that once he came there, he was then informed of the reason for the review. And the basis for his placement on security detention was an objective basis that came from his prior conviction on the disciplinary charges. So the prior hearing was necessary to give him notice in terms of his knowledge of the reasons. But as I previously mentioned, I think the Constitution would be satisfied if you had the review without his presence, as long as after that review, he received information informing him of the reason he's being detained and has an opportunity to respond to that. That is what the minimal due process requirements are. Now, you know, we're separating the due process under Hewitt from the due process under Wolf, and it's referred to as...
What about the 48-hour notice policy? I understand you don't think this applies, but it does seem to apply because the policy itself states that recommendations for placement in security detention status within the definition is included in the definition of status change for which the 48-hour notice applies.
Your Honor, I think...
So let me start again. The inmate classification plan policy provides a reclassification review will take place on an annual basis. Classification review may also be conducted as a result of a status change. Inmates will be provided with notice of their hearing at least 48 hours prior to the same. And the policy then defines status change to include recommendations for placement in security status, which is what was happening here, I thought.
Right, Your Honor, there are many policies in place, but the SCDC's position here is that once you are in the RHU, which is where he already was located because he was on disciplinary detention for a limited amount of time to get a hearing, that the only applicable policy is the RHU policy. And again, that...
Well, where does it say that?
Well, Your Honor, our clients have testified to that in the affidavits that are in the record. That they're
so it's just they're saying that. Where's it written down?
Well, the RHU policy says that it applies. The RHU policy is completely in the record on page 118. And that
isn't that the one that provides the 48-hour notice?
Well, no, Your Honor. There is a 48-hour notice provision contained in this policy for transfer to SSR, or the Supermax unit, just as the Supreme Court, required in Wilkinson. If you're going to go to
and for a status change, and a status change includes placement in security detention status. But I guess you're saying he was already placed in security detention status, and that's why it doesn't apply?
He was already in the restricted housing unit, and therefore...
And okay. And Judge Quattlebaum, I'm sorry, I interrupted you.
No, I appreciate that clarification. But Mr. Chandler, isn't your position on that even if you're wrong and you were entitled to that, that's maybe a statutory or administrative violation? But the issue here is whether or not this process satisfies Hewitt, because otherwise you're walking into a summary judgment question if you're debating those issues, right?
You're absolutely correct, Your Honor. You're absolutely correct. I'm telling you what our understanding of the policy is, but what the policy says and what it doesn't say doesn't impact the central question, which is whether or not this procedure satisfied minimal due process. That's a constitutional question, regardless of whether an employee maybe misconstrued a policy. It doesn't matter. They're not constitutionally liable for a misreading of a policy. They're liable if they violate the procedural due process rights of the plaintiff. So I agree, Your Honor. I see I'm out of time. Thank you.
You are, yes. We're happy to hear from you, sir.
Good afternoon, Your Honors. May it please the court. My name is Corey Patterson. I'm with Nelson Mullins, Raleigh and Scarborough. And I represent Mr. Fred Halcomb, who's the appellee in this matter. In Baldwin v. Hall, it states that for more than a century, the central meaning of procedural due process has been clear. Parties whose rights are to be affected are entitled to be heard, and in order that they may enjoy that right, they must first be notified. Your Honors, we respectfully request that from the district court's ruling, Mr. Halcomb was denied the very basic and primary constitutional right, and that's the right to notice prior to a serious deprivation. As Mr. Chandler has already indicated, they admit that he didn't receive notice prior to this classification hearing. Clear in the record, Mr. Halcomb was actually denied notice prior to his classification. They fined him for security detention for an indefinite period of time.
Mr. Patterson, if I could interrupt you just briefly, where is your authority that in a prison context, in terms of a confinement type decision, that an inmate is entitled to advanced notice of the hearing?
Your Honor, that's a good question, Judge Quattlebaum. I think that we turn, to answer that question, I think we have to look at Nkuma, and we also have to look at Wilkinson, as well as Williamson, which was in 2018. Although it doesn't say advance notice, I do believe that if you look at those cases, it talks about having meaningful review. I think it was
meaningful review is afterwards, right? You're right to challenge it after the decision is made. That was important in Nkuma, where there was no such thing, and so. But in terms of advance notice, I think the Wilkinson case. I think that's I may be mixing up my cases that start with W, but I think that case did maybe have advance notice, but Nkuma was pretty clear that we're not saying that type of notice is required. And I don't think we said in Nkuma advance notice was required. Maybe it should be, and maybe it's a violation, but the question is whether it's clearly established. And I didn't see that in Hewitt, and if I'm missing it in either Supreme Court or our cases, that advance notice is required, I'd like to hear that. If not, it seems like it's kind of hard to argue that it's clearly established.
Well, Your Honor, I do believe that it's clearly established, and solely when you look at Williamson, Williamson provided at least that, and Mr. Williamson was a pretrial detainee, but in Williamson, they said that you have to have notice prior to a deprivation. And so it kind of begs the question, like, what exactly is notice, right? Notice is the ability to know something in advance. Just taking it in the context of our everyday ins and outs of being attorneys. We notice depositions. That's allowing someone to know something in it. Mr. Halcomb in this case didn't know anything outside. He had just finished his hearing on April the 14th. He's put in front of a board on April 18th with not knowing exactly what that hearing is for. And so I think that when you look at the opinions of Nkuma as well as Williamson, I think that they move towards that type of notice being.
Mr. Patterson, don't all of those opinions, Hewitt, Nkuma, and Williamson, say that some notice is required? And I guess you're arguing here that your client received no notice. However, is that right?
That's correct.
That he received no notice. However, what about the fact of the hearing 4 days prior? Didn't that provide your appellee with some notice?
No, Your Honor, I don't believe so. And I think when Mr. Chandler was speaking, they're two separate things. So the hearing that he was having regarding his infractions and the disciplinary issue, once that was finished, he was given a sentence. That sentence was 60 days in disciplinary detention. And at that point, he was starting to serve his disciplinary detention sentence. And then 4 days later, he gets put in front of the ICC board. And he's already received his 60-day disciplinary detention. So what is that hearing for?
Right.
But Mr. Patterson, if I grant you that it seems as if he was that hearing began and he was transported to that hearing and he did not know in advance what it was for. But I think he contends that he should have had advance notice so that he could have been prepared to talk about what his cellmate might have done or not done. And in that prior hearing, he was actually successful in defeating one of the claims, a cell phone claim, by making that showing. And so maybe I'm getting into an issue that's different than was process granted as to whether there's, whether it made a difference. But it seems to me the whole reason he claims he did not have notice is kind of inconsistent with what happened in the prior hearing.
And I understand exactly that, Your Honor. Mr. Halcomb, when he initiated this suit, he argued that he was denied that 48 hours in advance because he felt that he did not belong in security detention because his roommate claimed more stuff, mainly the possession of the hacksaw. And so in claiming the possession of the hacksaw, that removes the Class 1 escape tool. I believe that he was convicted of. If you remove the Class 1 escape tool, that eliminates him having been one of the factors in being put into security detention. And so with removing that was his motivation in actually getting his roommate to at least take the blame for that sentenced him to indefinite time, we would argue, in security detention.
Do you have anything further, counsel?
Yes, I think, Your Honor, it would be at least if we could look at just a few things. I go back to the words of meaningful review. And I do that solely because it was mentioned in Nkuma, but it was also mentioned in Williams. And the having a meaningful review, although that's for afterwards, as Judge Quattlebaum pointed out, I do believe that it goes to the whole process that's due for an inmate. And, in order to have a meaningful review, you actually have to know why you're there, why you're present, and actual deprivation that you look for. So, Mr. Halpin he didn't have notice of any of that. I think in Nkuma, Judge Thacker, you let me know if I go astray on this one, but in Nkuma, the court mentioned briefly about the presence of the actual inmate being there for his review. And so I think for the policy that we have before us right now, if Mr. Halcomb doesn't have notice, there's really no reason for him being. It doesn't make the hearing very meaningful for him. He's not able to provide anything else.
Well, opposing counsel, I thought he said he might not have even needed to be there because it's he categorized it as a non-adversarial proceeding that he didn't even need to be there. So I wonder why they even brought him there. Must have needed to be there.
I think he might. I do believe, in looking at the policy for SCDC was changed due to Nkuma, but also I think that the policy that SCDC is looking at now or has before this court now is they use kind of the Wilkinson type of multi-tier, making sure that there were things in place. And I think in Wilkinson, the court mentioned, the presence of inmate actually being. But again, I would say that the inmate does need to be there. I do think that should be required.
But Mr. Patterson, I think, and it may be under a Matthews analysis. We really haven't spent a whole lot of time with that. But doesn't Williamson pretty squarely place our focus on Hewitt? I mean, Williamson says that based on the opinion in Acuna, our question is, what does Hewitt require? And I guess there could be subsequent cases that refine that, but doesn't Hewitt say what Judge Thacker just, I think, attributed to your colleague, that a informal non-adversarial process satisfies due process if you are told of the reasons for the charges and then given a right to challenge them, even if it's after the fact?
Yes, and that is true, Your Honor. Yes, Williamson,
so he wouldn't have had to be there under Hewitt, at least.
I would say, Your Honor, that he would. Let me take a step back again, because I said that's a difficult question to answer, solely because although it's non-adversarial, he still would have to. It would pull us back to why he would need, notice and a reasonable opportunity to be heard. And so I think that they also mentioned, we're focusing on the notice piece, notice portion, but I also think that the opportunity to be heard is kind of one of the mainstays of procedural due process. And so with him being there, that this opportunity to actually be heard, and at least object to the ICC board and say, hey, no, that's not correct. My roommate, he also assumed that particular, he assumed that escape tool, or he assumed that charge. And so that's what I would think, that the opportunity to be heard puts him actually there at the end to his objections to his case.
I can't hear you at all.
Oh, I stopped talking, Judge Bob.
Oh, I'm glad I couldn't hear you. Oh boy. Well, do you have anything further for us?
Nothing further from the court. I think I would, or nothing further from the appellee, Your Honor. I think I would at least mention that Ms. Ravenel, she is the chair of the ICC board. She has the ability, I think that, pulling a step back, with her being able to decide whether Mr. Halcomb remains in security detention, placement, she has the ultimate control of when those hearings are made and scheduled. She has enough way as well as enough discretion at least to administer the policy correctly. And I think Nkuma kind of put everyone on notice that, the security detention, which is essentially solitary confinement, it's an administrative segregation, it's solitary confinement, especially when you look at Mr. Halcomb's affidavit explaining the difference between simple population and security detention. But Ms. Ravenel had the ability to, at that point, pulling Mr. Halcomb in at, I think the time was like 11:18 for the hearing. He gets in there, he says he doesn't know what's there. She could have just said, all right, we'll just end it. We can provide you notice, 48 hours notice that, throughout the entire SCDC policy for classification, we'll provide you 48. Then you can come explain to you reasons why recommend security detention. That would have been, I think that would have helped Hewitt, that would have created an issue. But not having that notice prior to that hearing, I think that is why.
Well, you recognize the difference between what would be what you would like, what would be preferable, what would be meet the highest standards of good conduct and what is constitutionally required, right?
Oh, absolutely, Your Honor.
Okay.
What I would like does not go into this analysis at all. But what is constitutionally required is is some notice, and is what the district court in this case described as fair notice, and that did not happen in this case. There was no notice, and no notice is required, and it's clearly established that it's
I think we understand your position. Thank you. Counsel, is there any rebuttal?
Briefly, Your Honor, I'd like to respond to a question Judge Thacker raised about whether or not the inmate needed to be present. And I think I want to clarify my answer to distinguish between constitutional requirements and what the policy requires. Constitutionally, if you look back at the Hewitt case, the court states that ordinarily a written statement by the inmate will accomplish this purpose of presenting his views, although prison administrators may find it more useful to permit oral presentations in cases where a written statement would be ineffective. So that's the basis for my statement about whether he needed to be present. But after
right, and that goes to the opportunity to be heard. It's a notice and opportunity to be heard. So do you concede or not that the appellee was required to be provided some notice?
I couldn't hear the part of your question.
Do you concede or not that the appellee was required to receive some notice prior to this April 18th hearing?
I do not concede that he was required to receive notice of when the SP hearing would occur.
So do you agree he was required to receive some notice of what?
Well, the Nkuma summarizes this wonderfully. It says it says that the inmate must receive, quote, notice of the grounds for his ongoing confinement. So the plaintiff at some point, not necessarily before the hearing, but certainly makes more sense for him to have knowledge of what the subject matter is, which he did.
And you say he received that at the April 14th hearing, right?
He received that when he received notice of the April 14th hearing on March the 31st. He received that at the April 14th hearing. And then he received that again when he got the recommendation from the security detention board as shown through his appeals. He filed 2 appeals that are in the record that demonstrate the depth of his knowledge regarding both institutional policy and the law.
And just so I understand what's happening here, opposing counsel said that the first hearing, April 14th, was where he was found guilty for the disciplinary infractions and received a 60-day sentence for that. So what was the second hearing for?
Okay, so the first hearing was a disciplinary hearing under Wolf.
Right.
The hearing that we're referring to as a hearing is more correctly perhaps described as a board review. It is simply a security detention review of the existing record to ensure basic fundamental process is met. And the Wilkinson, in 2005, the Wilkinson court described that as allowing the inmate a rebuttal opportunity so that the inmate is not mistaken for another or singled out for insufficient reason. So those are the basic things that are being reviewed at that SD review, Your Honor. Are you the inmate? And is this your record? And based on this record.
And when was he told that those were the basic things that were going to be reviewed such that he could have a rebuttal opportunity?
At the hearing, at the SD board review. But then again, he received notice subsequent to that of the decision, which he then is allowed to further voice his position in response to, which he did twice through a step 1 appeal and a step 2 appeal. And as far as his presence, the second part of that position, Your Honor, is after Nkuma, the policy was improved to require physical presence. So it's not an optional situation. It's mandatory that he be there per policy, if not per Hewitt versus Helms. Now, he could refuse to attend, but he has the right to be present. And so, Your Honor, at its heart, plaintiff's original complaint in this case was that he needed to know the date and time of the review so he could have witnesses there. And plainly, he has no right to witnesses under a Hewitt v. Helms review. And that, in and of itself, I think encapsulates the problem with his claim. He is blurring or attempting to blur the line between the due process afforded for a disciplinary review, which he fully went through, and the due process associated with a security review that is not punitive, but for safety and security of the institution, which by definition requires a lesser standard. And so, Your Honor, we think that applying that lesser due process standard using the Matthews factors, the only conclusion is that he received the minimal due process that is required under the Supreme Court precedent. And that's just on the first prong of qualified immunity. We've addressed the second prong in our briefing. I see that I'm out of time and happy to answer any other questions, but I thank the court for your consideration.
Thank you very much. We'll go directly to our third case. We're happy to hear argument in our third case, number 19-1977, Western Star Hospital Authority versus City of Richmond. Counsel, whenever you're ready.
Good afternoon, Your Honors. Counsel, may it please the court, Luke Haskamp on behalf of Appellant Western Star Hospital Authority, doing business as Metro Health EMS, which is how we refer to the party. Thank you for the opportunity to be here today. Your Honor, subject to your questions, of course, I'll try to focus on our monopolization claims and specifically two key issues relating to state action immunity. One is the clear articulation standard, and two is the market participant exception. Now, with respect to the first, the ultimate question is whether the City of Richmond and the Richmond Ambulance Authority have acted pursuant to a clearly articulated state policy to displace competition in the market for non-emergency transport. That's the standard they have to meet to be entitled to state action immunity. And when you look at Virginia's entire statutory scheme, you see that the focus is on emergency medical services, setting up a statewide system so there's a plan in place when someone faces a medical emergency, that when a person dials 911, someone responds. The statute isn't addressing non-emergency services. And when you consider that, as well as the directives of the Supreme Court to narrowly circumscribe this disfavored doctrine. We think state action immunity should not be available here. On the second issue, that is just whether to apply a market participant exception. And the rule we propose is a straightforward one. If the municipality is acting as a regulator, immunity may apply. But the minute it steps into the market, engages in commercial activity, it's treated like other private actors. That is, it just can't engage in anti-competitive conduct. It has to play fair like other participants.
Has any court of appeals adopted such a theory?
Not explicitly, Your Honor, no. There's a little lack of clarity. There are courts that have, I think, at least implicitly endorsed it in dicta or explicitly endorsed it in dicta. And there are courts.
Well, there are courts that have said it might exist or could exist, or possibly in another case it could exist. Nobody has said it does exist.
Correct. No. But there are courts that have adopted the exception in other contexts, including this court.
Counsel, let's assume you do not prevail on the first point you made, that we think there is a sufficiently clearly articulated policy. Are you saying that you need, I know you made other arguments and we can talk about them, but by going to the market exception, it sounds like that's a tacit acknowledgement that you really need that in order to prevail, so long as there is a clearly articulated state policy to displace competition among this type of non-emergency use. Is that, am I understanding where you're going correctly?
Yes, Your Honor, that's correct. I would frame it as we think we only need to win on either of those points to get this sent back to the district
But you have
court.
to win on one or the other of those points.
Absolutely, yes. And Metro Health can, even if we lose on the clear articulation standard, we still could prevail on the market participant exception if this court recognizes that, regardless of if the city and RAA are acting pursuant to a clearly articulated policy. We think this additional rule should apply when they step out into the marketplace.
Well, counsel, I get that there are comments that exception might apply, both from the Supreme Court and the preemption case that you referred to from our court. And I think it's fair to say that theory hasn't been rejected by our court or the Supreme Court. But if that theory were kind of baked in to the Sherman Act and its law, Hallie couldn't stand and Phoebe Putney couldn't stand, could it? Or could they?
Certainly, Your Honor. Hallie is a great case to talk about. There's, I'm sorry, you said Hallie and Phoebe Putney. Both of those cases.
Aren't the municipalities in there or political organizations related to the municipalities, aren't they market participants in both of those cases?
Yes, they are, Your Honor.
Then it goes back to the judge's original question to you. We'd have to be overruling those cases.
No, Your Honor. I'm sorry. I don't think you do. Neither of those cases, I think, explicitly rejected what the rule we'd be proposing here.
Well, they implicitly rejected it because a market participant was involved, right?
I think they're yes, Your Honor, but I think they were acting in Hallie. The parties were acting to a clearly articulated.
Right, but we were talking.
Got it.
I'm sorry. Yes, I see your question here, Your Honor. But I think the concern that we've seen with the Supreme Court that's developed over the last few years with the North Carolina Board of Dental Examiners case and the Phoebe Putney case, we're seeing this evolving concern about market participation.
Well, of course, North Carolina, the regulators were private. They were regulating, but so it's not the same situation as we're here where we have a public entity, right?
Absolutely, that's correct, Your Honor. But I think what was important in the North Carolina case was the activity in which they were engaged. The quote, real danger that when an actor is participating in the market, he or she or it is able to act in furtherance of its own interests rather than the governmental interests that the state has set forth. And I think that is exactly what's happened here.
Well, it may be. I mean, it may be, but I mean, I guess its own purpose when it's a city and a political organization related to the city is inherently public. And so isn't that the point that I guess that goes back to your clearly articulated purpose argument, because if it's is being acted even in an anti-competitive way pursuant to a clearly articulated state purpose, that seems to be under the current law permissible.
It may be permissible under the current law, Your Honor. I mean, we do recognize we're asking the court to create some law here, but we think it's we think for the reasons articulated in the North Carolina case and Phoebe Putney, it's not as big of an ask as it seems. That is a real concern that the court seems to be focusing on in the last few years. And this case presents a very good example of why that is. And if just to jump to the clear articulation standard, I mentioned this is a disfavored doctrine meant to be strictly limited, narrowly circumscribed. And we should also keep in mind that the default rule is that antitrust laws do apply against municipalities, right? Which is different from states. States, we do have those federalism concerns. We do have sovereignty principles. But that isn't true for municipalities. There aren't those same federalism concerns, sovereignty concerns. It's only when the municipality can show that it is acting pursuant to that clearly articulated and affirmatively expressed policy. And the court, we think in Phoebe Putney, added a more rigorous application to that test. It was worried about courts applying the Halley test, the Mid-Cal test, too loosely. And it added the inherent logical or ordinary result of the exercise of authority delegated by the state legislature. And not only that, it's not enough that the state contemplated anti-competitive conduct. It had to do so in the market where the challenged activity took place. And one of the clearest examples supporting that reading is the 11th Circuit's decision from last year in the Diverse Power v. City of LaGrange, which presented a scenario where the municipality had authority pursuant to state statute to regulate water services and sewage services, both of those utilities. And the statute anticipated displacing competition in those markets. But then what the municipality did there, the city did, is took it one step further. They attempted to displace competition in a third market, the natural gas market. And they
counsel, the only way you can make that analogy is to go back where you started, and I'm sorry I took you off it, when you said that, okay, what they've done here, what the city has done is to regulate emergency medical services. And that's all. And they are here trying to regulate vehicles. But in fact, the statute says emergency medical services vehicles.
Yes, it does, Your Honor. It absolutely.
No, I'm just not sure where your argument goes. It is expressly in the statute here. So it has been expressly taken over by the city here. It wants to regulate the vehicles.
For sure. Yes, Your Honor. We do not contest the statute contemplates or discusses EMS vehicles for sure. But that's certainly within the context of setting up a statewide emergency medical services system. That's the focus.
But why isn't, counsel, why isn't it, why doesn't it further, the statute at issue says its purpose is to ensure that there's continuing emergency medical services. Why doesn't it further that purpose to regulate emergency vehicles used in a non-emergency setting so that there's sufficient revenue to overcome the fact that they don't make enough providing emergency services? I mean, it looks like, and maybe that's not the reason, but it seems to me they probably have a deficit on emergency services because many people are indigent. And so in order not to use other, revenues of the city, they, have higher charges for emergency services if they use EMS vehicles. And that may be real bad for the VA, and it may be real bad for taxpayers who aren't in Richmond who have to pay for it, but it seems to me to be consistent with that purpose.
Your Honor, I would disagree. I think that...
You would disagree with the purpose? That's what they clearly are doing, right? Your people want to skim off the less expensive things and provide services for those, right?
And so I think that I don't, Your Honor, I don't think our client would want to skim anything, but what I think
What's
that
the charge of the less expensive services?
Yes, and I think what's important there is I think that it highlights why the state was contemplating emergency services when it set up this system. It knew that the free market wouldn't necessarily deliver those services efficiently and for all citizens, unlike the separate market. I think there's little disagreement that there's this is a second market for non-emergency transport services.
Yes, but what Judge Quattlebaum is just telling you is the reason why they would include the non-emergency vehicles in that. And that's a perfectly legitimate reason, isn't it? It may not be one we like, but if you're the city, it's a perfectly legitimate.
It may be, but I think, and Your Honor, I'm about to run out of time, if I can just...
No, sure.
I think you have to go back and look at the statute and see if that's clearly articulated in there. And I'd point to section, this will be 111.4 paragraph B, which says quote, the board shall classify emergency medical services agencies and emergency medical services vehicles by type of service rendered. The state is saying what matters is the type of service rendered, not the form in which it comes, an ambulance or EMS vehicle. When the VA contracts to have EMS vehicles transport its patients, it's doing so for the medical services provided, not
but counsel, you and I'll let you finish. I know you're over your time, and maybe you address this coming back, but
sure.
That B says in addition to the powers set forth above, and A lays out all the things that we were talking about before. So it looks like, to the extent you're right about B's scope, it's in addition to and it doesn't change what happens with A. And A is where it seems like all the action is in this issue.
And Your Honor, I'm happy to finish now or wait for rebuttal.
Well, why don't you wait for rebuttal, and then you can also talk about whatever the other side said. Thank you.
Yes, thank you, Your Honor.
Counsel?
Good afternoon. May it please the court. My name is Craig Merritt of the Richmond, Virginia Bar. I'm here on behalf of Richmond Ambulance Authority to address the antitrust issue. Mr. Marks has reserved some time to talk on behalf of the city about the preemption issue. I'm glad that the colloquy with counsel ended with some of the facts in the record, because it's an important point that hasn't gotten enough focus in these briefs. There are two clusters of facts we would ask the court to look at that are in your record, in your appendix. In the second amended complaint, Metro says at paragraph 36, and this is in the joint appendix at page 21, that EMS vehicles with advanced life support and trained crews can be used for both emergency and non-emergency services. In their brief, opening brief at page 6, with regard to the VA, Metro tells you that the VA requires ambulance-type transport vehicles with basic and advanced life support equipment in case something goes wrong. Now, it's important because it means that these same vehicles are on the supply side of both the emergency and the non-emergency market. We also know from that same paragraph 36 in the second amended complaint that EMS level transport vehicles with advanced life support are expensive. And thus we set up the problem. How do you generate a revenue stream sufficient to cover the expense of these vehicles? Well, we know one thing. The Metros of the world want no part of that. They don't want to be taking the low revenue stuff, as they told the city in joint appendix at page 385. In their submission to the city, Metro says, quote, Metro has no interest in providing any emergency services to any private residents, cities, or local government within the Commonwealth of Virginia, end quote. Thus, the cherry picking problem that municipalities have to deal with, because the Metros of the world don't want to deal with those low pay customers. The answer to that is in a second cluster of facts that you'll find in the record, having to do with the sovereign authorization that the General Assembly of Virginia gave to municipalities generally, and specifically to the city of Richmond, that allows them to address this problem. We've already had some discussion of Virginia Code 32.1-111, but something that is glossed over fairly regularly in this discussion by Metro is the Enabling Act, which is a separate piece of legislation from the Virginia General Assembly. Because remember, we're a Dillon Rule state in Virginia. The municipalities don't do anything without legislative authority. And if you look at Joint Appendix, page 90, working in conjunction with that general state statute, you have an Enabling Act, which further and very specifically authorizes the city to set up an authority that has the power to provide both emergency and non-emergency services. So the authorization is explicitly there by combination of the statute and the Enabling Act. We encourage
So counsel, Mr. Merritt, if I could interrupt you, assume I want to turn your attention away from the clearly articulated purpose issue for a second. Appreciate the points you've made on that. Your colleague really didn't address this issue, but to me, the thing that made this case maybe different, or I think definitely different, maybe not different in a way that legally matters, maybe it does, relates to the active supervision issue that North Carolina Dental talks about. And one of the reasons, as I recall, North Carolina Dental said the state action immunity didn't apply, or it was several reasons. As Judge Mott said, those were private participants. They had their private interest. But also they weren't accountable politically, or relatedly, they weren't accountable politically. So I really kind of want to deal with that issue, that political accountability. And it seems to me, in theory, Richmond's a political, obviously as a municipality, there's political accountability there. And the RAA's people are appointed by the mayor. And so there's, arguably in theory, political accountability there. But the charges that are made to the VA are borne by people outside of Richmond. They're borne by everyone, whether they're even outside of Virginia. So to the extent there's anti-competitive behavior, and I think it's pretty clearly competitive behavior, it hurts, the taxpayers as a whole who don't have any ability to exercise their displeasure to this type of situation. And that seems different than the other cases, factually, for sure. So, first of all, do you agree that that's a factual difference? And B, are we just supposed to say because it's never come up, it doesn't matter, or does it matter?
I agree that it is a fact. I don't agree that it's a factual difference. It is a fact that when you put any sort of a system in that is anything other than a pure free market free-for-all, there is going to be a reallocation of the cost of the service among classes of people. That's a given. That's true of almost any kind of regulation we can imagine, just as a matter of economic theory. The idea that this is a new issue in state action cases, I don't agree with. Because if you look at any number of state action cases that involve any form of state regulation, costs are imposed on the people who are complaining about the system. That's how you even get to the Parker question.
Yeah, but the point of
market dislocation.
Yeah, but the point of North Carolina Dental is that if the people who complain can kick the folks who set the system up out of office, then there's some checks and balances there. In this case, it seems like that's something that's missing, or at least it's missing for the vast majority of the people who have to pay the higher cost that the VA incurs.
I have no reason to believe that in Halley, the surrounding towns that sued the city of Halley had any ability to elect the city council of the city of Eau Claire. This is not.
So you're saying in Halley, the complainers, and that's helpful. That the people who are complaining are in towns outside the city, and therefore couldn't kick the folks who put that system in place.
Exactly.
So you're saying that's not a difference. Okay.
I don't think it's a legal distinguishing point. I truly do not. The other thing
it could be, counsel. It could be a distinguishing point when you have no political body involved, as you did in the North Carolina Dental case. It's just different considerations then, because somebody is politically accountable for the regulations here. Maybe not your representative, but the legislature writ large, the city itself, and so they're politically accountable, whereas that was not the case in the North Carolina Dental situation. Isn't that right?
That's right. But the North Carolina Dental case, generally speaking, is factually an opposite for this reason. If you look at the whole line of Parker cases, back to the foundation of the doctrine, there has always been a line of cases that you can follow. You go through Goldfarb, you go through Midcow, you go through Parker versus Berger and FTC v. Tycor, and all of those cases are dealing with precisely the problem that you have in North Carolina Dental. That is, you have a gauzy cloak of state activity that appears to coincide with what is essentially private, horizontal, anti-competitive conduct by people who are active in the market. That is fundamentally different from an RAA or a municipality, which have a direct authority from the General Assembly to do what they do. And that's why North Carolina Dental itself, in Part 3B of that opinion, it specifically identifies the Howley municipality limitation on that rule for active supervision and distinguishes it from the more general Mid-Cal rule that it goes on to apply against that state body. North Carolina Dental, fairly read, embraces Howley when it comes to the type of defendants that we're talking about in this case. It embraces Howley and reasserts it with regard to municipalities. Last point, if I may, the Howley test has not been modified by Phoebe Putney. And the vehicle by which Metro tries to accomplish that is a reading of the 11th Circuit's opinion in diverse power. But I think you need to read diverse power fairly. Reaching to find a circuit split on this, in our view, is a pretty strong reach. In diverse power, you will see a discussion that begins at page 1274. We're 934, Federal Reporter 3rd, 1274. It's Part 3B of the opinion. And for several pages, the 11th Circuit talks about Phoebe Putney, in which the Supreme Court reversed the 11th Circuit. And essentially several pages are spent talking about why, had the Supreme Court not moved the ball on them, the 11th Circuit would have been correct. Now, regardless what one thinks about that analysis in diverse power, when the rubber hits the road, when it comes time to make the decision, diverse power itself applies Howley. In the discussion beginning at the bottom of 1276 and continuing through 1277, it embraces and grapples with what were the facts in Howley and what are the facts here, how are they distinguished, how are they the same. It then follows with another aside about how the Supreme Court moved the ball, but then at the end of the day, it says, perfectly consistent with the Howley test, we think it's safe to say that the tying of an unrelated service in a different market to the provision of water service falls outside the statute's grant of immunity. In other words, we looked at the statute under the Howley test, and this is simply too far a reach. We cannot infer what Phoebe Putney is telling us it's permitted to do. So you really have to overread what happens in diverse power to try to generate a circuit split or an argument that Phoebe Putney abandoned Howley. In fact, Phoebe Putney, if you look at 568 U.S., starting around page 227 and 228, there is a discussion of the Parker test that includes Howley, and then Phoebe Putney says, the principle articulated in Boulder controls this case. Why is that? Because Boulder is a case in which the evidence showed that the position of the sovereign was one of complete neutrality. You couldn't find an authorization no matter how hard you tormented or tried to read the statute. That's what controlled in Phoebe Putney. You don't even get to the Howley issue in Phoebe Putney because you can't find anything to analyze in the broad neutral grant of power that's been given. So we think that this court is being invited to take a view of Phoebe Putney's effect on Howley that is really a pretty long stretch, and we would encourage you not to do that because we think it requires you to put a reading on Phoebe Putney that's not fairly borne by the actual language of the opinion.
Thank you.
Yes, ma'am.
Does your colleague, do you wish to add anything, sir?
Good afternoon, Your Honors. My name is Wirt Marks on behalf of the City of Richmond, and I'm prepared to address the appellant's preemption argument. It hasn't been brought up by the appellant, but our position is that the district court correctly concluded that the amended complaint failed to allege any conflict between the city ordinance and the Competition and Contracts Act. Competition and Contracts Act requires an executive agency in conducting procurement for services to use competitive procedures. In their own request for quotes they put out in this case, they specifically provided as a requirement of that process that any service provider proved that they had acquired a permit under the city's ordinance and directly require compliance with the city's ordinance in order to be able to.
Council, we can't hear you.
I'm having a hard time hearing.
I'm sorry, Your Honors. Is working? Is that any better?
Yes.
Yes.
I apologize. And so our position is that there's no conflict with the ordinance. In addition, the contracting.
So, Mr. Marks, can I ask you a question? Can you hear me?
Yes, Your Honor.
It's not about the preemption issue, and if it's unfair, I'm sorry, but I'm just curious. Would your clients, would the city and the RAA be immune from interference with? I don't even know if Virginia has an interference with prospective contractual relations claim. Would they be immune from that? Would they be immune from civil conspiracy? Would they be immune from a state unfair trade practices claim? Do you know? And that's probably not really framed. I'm just, but if you know the answer to that, I appreciate it.
I don't know the answer to that, Mr. Merritt may, but Your Honor, frankly, off the top of my head, I don't. I believe they would be, but I've not specifically looked into that issue.
Mr. Merritt, do you know the answer to that question?
Your Honor, I believe that under general principles in Virginia, there would be sovereign tort immunity, except to the extent it's waived. And there is a statutory provision that in some purposes waives tort exposure for sovereign immunity, but I can tell you I have not studied that in preparation for this argument. So beyond that gauzy 35,000 foot response, I get uncomfortable.
Thank you.
Your Honor, if I may add something to that question, from just a general principle of sovereign immunity with regard to the city, I think clearly the regulation of healthcare services falls in the realm of being a governmental function. And as a governmental function, the city would be afforded sovereign immunity on general tort claims related to that. As to contractual issues, I've not looked into that specific.
Thank you.
All right.
And so, Your Honor, it's our position that this is the Competition and Contracting Act is a broad act that covers many types of different contracts, and of course, reasoned in Virginia Uranium versus Warren, the same sort of reasoning applies where this is one small contract and piece, and it doesn't support a conclusion that even if there's a conflict between the Competition and Contract Act and the Richmond statute, that this one small area would supersede Congress's purpose of trying to promote competition in contracts. In addition, clearly the VA made a requirement of the request for quotes that anybody that bids on complies with the city statute or ordinance. So, thank you.
Thank you very much. We appreciate your argument. Do you have anything in rebuttal, sir? Do you have anything in rebuttal, sir?
Yes, Your Honor. Thank you very much. First, I want to note that there's no doubt that the services being provided to the VA are non-emergency services. That no one contests otherwise. No one contests there's two separate markets here. We also have to understand the VA sought to competitively bid this work. It has an obligation under federal law, in fact, to bid it. But we have a scenario here where they can't go with the bidder they want to go with because this monopoly exists and this has been allowed to perpetuate for really decades. I also want to point out when we consider all these questions, the very end of Phoebe Putney talks about with these questions, because the doctrine's disfavored, if there are doubts, there should be resolved in favor or against finding immunity exists. And I think that's important to keep in mind for all these questions. Now, when we look at the statute, the key again is to keep in, did the state anticipate displacing competition in the market where the complaint of conduct occurred? And the statute, the focus is on emergency services. Now I know Council, Mr. Wirtz brought up Mr. Merritt brought up the Enabling Act. That is simply permission to act in the market. That's a classic Boulder statute. It does not say anything about displacing competition in a non-emergency market. That's the burden they have to meet. And again, state action immunity is an affirmative defense. This is the city and RAA's burden at this point. On the active supervision point, again, the Supreme Court repeatedly expressed this concern about these situations where our parties are acting in the same markets that they're regulating and indeed controlling. And North Carolina's Board of Dental Examiners, certainly with respect to the RAA, there's the same lack of political accountability that was a, quote, real danger there. Also functionally, I just want to step back. There's clear differences between emergency services and non-emergency services. Right? I think we all understand that intuitively. You call your doctor for some things. You call 911 for other things. Right? And when you call your doctor, sometimes you get that recording beforehand that says, this is an emergency, hang up and dial 911. And it made sense for the state to set up a system to have a plan in place when you do have those emergencies. Now, going to the point about whether these cities, these communities can supplement their budgets based on profits, super competitive profits they derive in other markets, separate markets. I think that does not show an articulated policy to displace competition in that separate market. It doesn't. It emphasizes the fact that there are these two separate markets, one that's really not discussed in the statute. And let me see. Your Honors, at this point, I think our main point here is that it's very important to scrutinize this monopoly. That's what the Supreme Court has directed courts to do. A monopoly is perpetuated for decades. And ask, is this really what the state intended when it established its state emergency services system? Particularly where it has allowed this community to wield this power to further its own interests, a power that no other community in this state appears to have wielded itself. Right? The VA seeks to do business with Metro Health. It wants to go with the lowest bidder, but it's blocked from doing so.
Counsel, your time has expired. You can finish your sentence.
Thank you very much. Yes, Your Honor. With that in mind and the directives of the Supreme Court to narrowly circumscribe the disfavored doctrine, we think state action immunity is not available here. Thank you very much.
Thank you very much, counsel, for your arguments. My colleagues, would you like to take a break, or can we go to the last case today?
I don't need a break.
Quite a lot. Number 186627. All right, we're happy to hear argument.
Good afternoon, and may it please the court. Anwar Graves on behalf of appellant Travis Croft. This court should reverse the decision of the lower court because carjacking, under South Carolina law, is not a predicate offense under ACCA for three main reasons. First, because neither South Carolina's carjacking statute, case law, nor its pattern jury instructions define the term intimidation, this court must look to the usual and customary meaning of the term in order to ascertain the legislature's intent. And in looking at the usual and customary meaning of the term, intimidation includes nonviolent conduct. Second, a review of South Carolina case law, specifically where it determined that the statutory phrase force or coercion includes nonviolent conduct, reveals that South Carolina would similarly determine that the phrase force and violence or by intimidation would also include nonviolent conduct. And lastly, no legal imagination is required to hold that a realistic probability exists of one being charged with carjacking through nonviolent means. So starting with the first point, in looking at the usual and customary meaning of the term, intimidation includes nonviolent conduct. As mentioned earlier, the statute says by force and violence or by intimidation. The Supreme Court makes clear in Decomp v. United States that the legislative use of or to separate clauses within a provision is a strong indicator that each clause represents an alternative element or means in this case. And so if we look at intimidation and the usual and customary meaning of the term, courts generally start with the dictionary, specifically Black's Law Dictionary, which defines intimidation as unlawful coercion, extortion, and coercion is defined in Black's as compulsion of a free agent by physical, moral, or economic force.
Mr. Graves, if I could stop you there. I mean, I've read the briefs and think you probably at least have a point perhaps if you look at intimidation just in isolation. I mean, I think we can all think of intimidation in ways that wouldn't necessarily involve either violence or the threat of it. But is that our inquiry, or is our inquiry to look at it in the context of this statute, which requires the intimidation to be to take or attempt to take a vehicle while someone else is in it? And it seems to me that narrows the circumstances or the reach of intimidation.
So respectfully, Your Honor, I would disagree, and I would ask this court to consider State v. Richardson. In that case, the language was slightly different. It was force or coercion as opposed to force or intimidation. But in that case, which was a criminal sexual conduct case, the court affirmed that that's nonviolent conduct would apply. Specifically, in that case, there was a defendant pastor who used his moral and economic pressure to place the victim, or at least to compel the victim to engage in improper sexual conduct, or stated another way, sexual conduct that was without her consent. And so I don't believe that necessarily force and violence or by intimidation would require this court to look at it from a violent perspective. And I see Judge Thacker.
But isn't it a problem for you that there aren't any carjacking cases that have ruled in the way that you would interpret intimidation?
So in carjacking cases, I would disagree. Shropshire v. United States is the Eastern District of Tennessee. There, the court found that the carjacking statute, which uses the phrase by force or intimidation, was not a violent felony because the jury instructions defined.
Yeah, but Mr. Graves, in that case, the Tennessee court looked to Tennessee's pattern jury charges, which included language that was broader, that was broad enough to include, your perspective on that. Judge Thacker's question seems to me to be geared more towards South Carolina, and I don't think there's any cases in South Carolina where there's about carjacking, where the perspective you talk about has been held, and almost to the contrary, the exact same language, force or intimidation in robbery, which carjacking seems to be, if anything, a category of, or the Mitchell case says that a robber intimidates by threatening force. Now, I recognize that's robbery and not carjacking, but if it was robbery, it seems to me it'd be case closed, and even though it's not robbery, it seems to be a challenge for you. Why is the Mitchell case not pretty difficult for you to overcome?
So I would ask this court to consider United States v. Drummond, because I believe that this court answered that question there. And in United States v. Drummond, which was actually a South Carolina case as well, this court stated that the legislature is presumed to be aware of the common law, and its deliberate use of a phrase not rooted in the common law offense indicates that the legislature did not intend to mirror the requirements of the common law offense. So if Your Honor is correct that carjacking is assumed by South Carolina to be robbery of a car, then one would have to ask the question, pursuant to Drummond, why did South Carolina not mirror the language of robbery? It doesn't use the phrase putting such person in fear, which is the language of South Carolina's robbery statute. It doesn't use the term robbery. South Carolina elected to use the phrase by force or intimidation, which is very similar to force or coercion, a phrase that South Carolina courts have decided includes nonviolent conduct. And as Your Honor is correct, robbery is a common law offense. Of course, the interpretive rules are slightly different, but the reason why I mentioned what the legislature did is because statutory offenses, like carjacking, the relevant question is what did the legislature intend? And here, as this court stated in Drummond, the fact that they did not use that language signals their intent for it not to be robbery conduct. So, as I was proceeding, I was saying that the notion of intimidation being tied to coercion is seen in South Carolina's criminal code and also in its case law. I earlier mentioned State v. Richardson, which was criminal sexual conduct in the third degree, where the court found that moral or economic factors can coerce. Specifically, the court used the quote, authority itself intimidates, the implicit threat to exercise.
But going back to this other case you were talking about, what did you say that was, U.S. versus Drummond?
Versus Drummond, yes, Your Honor.
Is that in your brief?
It is. It's listed in my brief.
Okay.
Well, tell us a little bit about that. So recall it for us.
Sure, 1 second.
Aha.
Pulling up the facts myself, specifically with Drummond, and it's referenced in an appellant's reply brief. It deals with the notion of whether it was a South Carolina case, and specifically it was defining what the terms of a South Carolina statute meant. And this court specifically looked at it and said that if the legislature did not use the common law language, then therefore it signals an intent to depart from the common law offense. So that was the general background of United States v. Drummond, and it's mentioned on page 19 of appellant's is where it's first cited.
Well, if that, just kind of playing around with that argument, what South Carolina did, the language it did elect to use was the federal carjacking language, which has the intimidation language and has been held to require a threat of violence. So if you don't have the common law, if your argument is that South Carolina didn't use the common law language, and we look at what it did use, it's federal language that has been interpreted to be a crime of violence. So how does that help you?
Yes, Your Honor, and I just want to refer the court to page 24 of the reply brief for the Drummond language that I mentioned. But in answering your question,
thank you for that.
Okay, and Judge Quattlebaum, with regards to federal carjacking, appellant would argue that's a red herring, and this court went down this road in United States v. Winston when it was asked to apply the federal interpretation of robbery made by this court in McNeil to Virginia's interpretation of robbery. And this court in Winston said such cases are distinguishable from the present case because that decision involved this court's interpretation of the federal statute rather than our application of the state court's determination of a state offense. This court also noted that a state is entitled to define its crimes as it sees fit. So notably, while South Carolina used the phrase force and violence or by intimidation, it elected to not use the mens rea requirement that's listed in the federal carjacking statute, the mens rea requirement of intent to cause death or serious bodily injury. An appellant would argue that that mens rea limiter, applies federal carjacking specifically to a violent context. Counsel cannot think of one example where one would have the intent to cause death or serious bodily injury but not use violent force. However, counsel can think of many examples where one may use economic force or moral coercion to obtain property from someone else. And so the fact that mens rea requirement is not included is very dispositive, appellant would believe, in deciding whether or not the federal carjacking statute applies.
Why would South Carolina include carjacking in its list of enumerated violent crimes?
I'm sorry, you broke up at the end there, Judge Motz.
South Carolina includes carjacking in its list of violent crimes. Why would it do that if it's not a violent crime under South Carolina law?
Well, as you note in the carjacking, or as you can see in the carjacking statute, there are enhanced offenses for serious bodily injury, etc. And so it makes sense that it could be included in a violent crime context. But I will note for the court that kidnapping is also included in the violent crime list listed in South Carolina. And kidnapping is something that circuits have recognized is something that is not necessarily an act of predicate. I will reference this court to is United States v. Flores Granados, where it stated in dicta, this court stated that South Carolina's kidnapping statute would fall outside the generic definition of kidnapping, which would render it outside of the ACCA context. So simply because it's listed as a violent crime does not make it dispositive under ACCA.
Is there?
Sorry.
Go ahead, Judge Mott.
No, I was just going to say, I didn't suggest it was dispositive, but what we're trying to do is to see, well, how the state treats this. And it seems that's one piece of evidence about how the state does treat carjacking. Go ahead, Judge Quattlebaum.
Did you want me to respond?
Yeah, and kind of similar to that, maybe another point that's not dispositive that again, I think Judge Thacker alluded to earlier. And I just want to make sure we're on an agreement. And again, I'm not suggesting this means automatically you lose, but is there a South Carolina appellate decision that affirms a conviction of this statute where there is not a threat of violence?
There is not an appellate decision, Your Honor, but I believe that's handled in this court's decision in United States v. Aparicio Soria. That case involved Maryland's use of resisting arrest, that statute. And the government there, like it's doing here, cited to 38 published opinions in support of the notion that Maryland would never convict someone of a nonviolent approach to resisting arrest. And armed with this mountain of cases, the government asked this court to avoid exercising its legal imagination and find that it's a realistic probability that Maryland would apply resisting arrest in a nonviolent context. But Judge Davis refused this court's invitation. Specifically, in Aparicio Soria, the court stated that it has precedent from the Court of Appeals that states that all is needed is offensive physical contact, which would not be an act of predicate.
Would you have similar authority from the South Carolina Supreme Court?
So with regards to force and coercion, yes, Your Honor. And what appellant is arguing
in the carjacking statute?
No, not with force and coercion, which carjacking is force and violence or by intimidation. What appellant is arguing is that that's very similar to force or coercion. And force or coercion is something that South Carolina appellate courts in its highest court has deemed nonviolent conduct to apply to force and coercion.
So I think if we equate or say that intimidation is either the same or substantially the same as coercion, you think those help you, and I agree with that. I think our question is, do we do that, or do we use other cases where intimidation has been used in the robbery context, which I think is harmful to you? So that's kind of the fork in the road that you would ask us to go one way. I'm sure you will hear a different discussion in a little bit.
I'm sure my dear friend Ms. Staunton will argue something different, but I would argue that South Carolina did the work for this court in defining intimidation and coercion. And again, I point this court to State v. Richardson. The quote that's used in State v. Richardson is, "Authority itself intimidates, the implicit threat to exercise it coerces." So that's a distinction that South Carolina has made with regards to that. And using that language, it found that nonviolent conduct would apply in the criminal sexual conduct crime or criminal statute. And doing so, again, is force and coercion. And with regards to Your Honor's robbery point, again, I refer this court to United States v. Drummond. I think there is something to be read into by the fact that the South Carolina legislature did not use robbery or putting such person in fear. It used force and violence or by intimidation, like very similar to force or coercion. So the point that the last point that I was going to make on this app, unless there are any other questions, is that there are other examples in South Carolina code where intimidation is also used. Witness intimidation is an example. And in State v. Inman, the court found that intimidation in that context does not have to be violent. Similarly, in unlawful use of a telephone, that South Carolina uses intimidation in that statute, and again found that that does not need to be violent. The threat there does not need to be violent. So throughout South Carolina's case law, we see the use of intimidation and we see the use of force or coercion. And in both of those approaches, we see that it's not violent. And the only way that this court, I believe, can reach the decision that it would be violent is if it is read in conjunction with federal carjacking statute. And this court made clear in United States v. Winston that that's not the right approach. The right approach is not to evaluate the case absent intent from the legislature for it to be modeled after that federal statute. And so in United States v. Winston, it makes it clear that this court is not to look at the federal carjacking statute, but to look at South Carolina and its jurisprudence specifically in making their determination. And in doing so, as this court said in United States v. Abdul Shafi, you look at the usual and customary meaning of the term, and we also look at case law in the state.
Thank you very much. We'll hear from the government, and then maybe you'll have some rebuttal.
Thank you, Art.
May it please the court, Katie Stoughton on behalf of the United States. The Supreme Court of South Carolina, this court, and every other circuit court have considered what the term intimidation means when a taking can be accomplished by force or violence or by intimidation. Everyone has held that intimidation in that sense means a threat to use violent force. In addition, the text, the history, and the application of the South Carolina carjacking statute show that intimidation in this context means that an ordinary, reasonable person in the victim's position would feel a threat of bodily harm from the defendant's actions.
Ms. Stoughton?
Yes, Your Honor.
Ms. Stoughton, could you respond to opposing counsel's argument about Drummond, since it came up in his reply brief, and I don't think the government then has yet had a chance to respond to that?
Yes, Your Honor, I appreciate the opportunity. The point is taken that the South Carolina legislature, in passing the carjacking statute, did not incorporate the explicit language from the South Carolina common law robbery as it had been explained by the Supreme Court. But what the legislature did do is instead use a very specific phrase, by force and violence or by intimidation, that had only been used 4 other places in the law, and that's the 4 federal robbery statutes. And so to the extent that the language of the statute would point you away from South Carolina common law robbery and the Roseman decision, it would point you to these 4 federal statutes and Evans and McNeil. But at the end of the day, either of those roads takes you to the same place, and that's to a definition of intimidation that incorporates a threat to use violent force. So if I could first address South Carolina law, the statute, as you know, has defined carjacking as a taking of a motor vehicle by force and violence or by intimidation while the person is operating or inside the vehicle. A carjacking is just a specific kind of robbery. And so to determine the minimum level of force that South Carolina courts would require in order to complete a carjacking, this court needs look no further than the South Carolina Supreme Court's definition of intimidation in the context of a common law robbery. In Roseman, the state Supreme Court explained that the essence of the common law robbery charge is a taking by violence or by intimidation. And it defined intimidation as whether a reasonable person would feel a threat of bodily harm from the perpetrator's acts. In Doctor, this court held, based on Roseman, that intimidation in the context of South Carolina robbery necessarily involves, at a minimum, the threatened use of physical force. A definition of intimidation that equates to a threatened use of force finds further support in the opinions analyzing 4 federal robbery statutes that use this exact same phrase, by force and violence or by intimidation. And before I turn to those statutes, if I could first just address my colleague's argument that these federal cases are not helpful in this context under Winston. It's not the government's position that these federal cases are controlling or that they dictate the outcome in this case, but we do think that these cases provide very helpful context for how the South Carolina courts would define intimidation. And that's for 3 different reasons. One is the text of the statute. South Carolina legislature adopted the exact same phrase, by force and violence or by intimidation. The second is the history of the South Carolina statute. In the fall of 1992, Congress became the first legislative body anywhere in America to specifically enumerate the crime of carjacking. South Carolina just followed just a few months later and became the third jurisdiction to adopt a carjacking offense, and again incorporated the language from the federal offense. And third, about 10 years later, after the carjacking statute was enacted, the Supreme Court in Rosemond adopted this court's definition of intimidation under the federal bank robbery statute. So I think the text and the history shows South Carolina intentionally modeled its carjacking statute after the federal statute. If you look first at federal bank robbery, again, as I mentioned, Rosemond's definition of intimidation was taken from this court's definition of intimidation in the Wagstaff opinion, where the court held that bank robbery requires intimidation to be reasonably calculated to produce a fear of bodily harm based on the acts of the defendant. In McNeil, the court built on Wagstaff and held that the federal bank robbery statute is unquestionably a crime of violence under Section 924C's force clause. It explained that intimidation within that same phrase, by force and violence or by intimidation, simply means the threat of the use of force. Turning to the federal carjacking statute, in Evans, this court built on its holding in McNeil and held that federal carjacking, which again uses the same specific phrase, by force and violence or by intimidation, is also a crime of violence under Section 924C's force clause. And if I could address my colleague's argument about the specific intent element that's present in the federal carjacking statute but not in the state carjacking statute, the specific intent element doesn't change the quantum of force that's required to commit a carjacking by intimidation. And I would point the court to a few different places to reach that conclusion. The first is the court's opinion in Evans. Evans, of course, recognized that the specific intent element is a required element of the federal carjacking charge, but its analysis under the force clause focused solely on the by force and violence or by intimidation element. Second, the three other federal taking statutes, bank robbery, controlled substance robbery, and robbery in the jurisdiction of the United States, all use the same phrase, by force and violence or by intimidation, but they lack the specific intent element that's present in the federal carjacking statute. But regardless, all three of those statutes have been broadly and uniformly held by other circuits to be crimes of violence under various force clauses. And then finally, I would point the court to the Ninth Circuit's decision in Foltz, which I cited to in the 28J letter that I submitted earlier this week. There, the Ninth Circuit explained that what matters for purposes of a categorical approach analysis is the manner of execution of the crime and not any specified level of intent. So regardless of the heightened intent element that's present in the federal carjacking statute, we believe that it's the phrase by force and violence or by intimidation that controls the categorical approach analysis that the court is undertaking here. In addition to the specific text and history of the South Carolina statute, application of the carjacking statute in South Carolina shows that it requires a use or threatened use of force that's sufficient under Johnson. The cases involving a conviction for carjacking in South Carolina show that the statute is used exclusively to prosecute the use or threatened use of violent physical force. I cited to a number of cases on page 15 of the government's response brief. Each of those reflects an instance where the defendants used a weapon like a gun or a knife to overcome victims, and in many cases threatened to kill, in one case to sexually mutilate the victims. They didn't turn over control of the car. So in short, there's just no indication in the text, the history, or the application of the South Carolina carjacking statute that South Carolina would prosecute as a carjacking something that's accomplished by less than threatened use of physical force. If I could just briefly address the three sources that Mr. Croft has asked the court to consult instead of the application of the South Carolina statute. The government, of course, agrees that the word intimidation can have many different meanings in many different contexts. The Supreme Court has explained that the meaning of statutory language, whether it's plain or not, depends on context. And so with respect, I don't think that the appropriate approach here is to open the dictionary and find the broadest or most common definition for intimidation, because you have to look at the context in which it's used, and that's within the phrase by force and violence or by intimidation, and that's within the context of an unlawful taking. Second, as to other South Carolina crimes, Again, I believe that this is an attempt to divorce the word intimidation from the context and define it in the abstract. The specific statutes that Mr. Croft has relied on don't actually prohibit completing an act by intimidation in the way that the carjacking statute does. The criminal sexual conduct in the third-degree statute, which was at issue in Hamilton and Richardson, it makes it unlawful to use force or coercion to accomplish a sexual battery. It doesn't use the word intimidation in that statute at all. So even if the court were to look purely to dictionary definitions, I think the fact that the South Carolina legislature has used different forms of the word intimidate or intimidation or synonyms for the words intimidate or intimidation indicates that the legislature would have intended those statutes to have different meanings. Finally, as to the other federal court's decisions that find other state statutes are not crimes of violence, I think each of those cases is distinguishable, and the body of case law as a whole is in opposite here. In every one of those indications, there was some concrete indication in the state law. There was something like pattern jury instructions. In the Tennessee case, it was the defendant's own jury instructions, or a state court decision holding that a carjacking could be committed through something other than or less than a threatened use of force. There is no such indication in the South Carolina law. So the fact that Tennessee or Massachusetts allow a carjacking to be completed by something like coercion or without the use of any force at all simply has no bearing on how the South Carolina legislature has intended to define the term carjacking. If the court has no further questions, I would just reiterate that the text, the history, and the application of the South Carolina carjacking statute show that intimidation in this context means a threat to use violent force. South Carolina carjacking is therefore a violent felony under the ACCA's force clause, and the denial of Mr. Croft's motion for relief from his ACCA sentence should be affirmed.
Very much.
Thank you.
Do you have any rebuttal?
I do, Your Honor. And if I may, I want to play off of Judge Quattlebaum's fork in the road analysis that he mentioned earlier. So the first fork in the road is robbery. And I think that's disposed by Drummond. As discussed earlier, South Carolina did not decide to use the common law terms and common law offense. The second fork of the road is federal carjacking. And I believe that's disposed of in the United States v. Winston, where this court was asked to do the exact same thing, where the terms were the same when applied to the Virginia robbery statute. And this court refused an invitation saying that the federal context is not helpful in determining what the state means when they use a certain term. So then we're at that last fork in the road, which is what appellant is suggesting this court walk down. And that's where you examine the individual state and what their intent was. And so at bottom, I think this case can be resolved by a hypothetical. Let's say that we have State v. Richardson again, where the pastor has decided to use his moral and economic influence over someone that has a brand new car and says, give me your car, or I'm going to stop doing whatever it is I'm doing for your family within the church. Is there anything in the South Carolina statute that would prevent a prosecutor from charging that with carjacking? The answer is no. South Carolina did not choose to use the federal language of with intent to cause death or serious bodily harm, so there's no limiter in place for that. They did not choose to use putting such person in fear, which is the robbery language that South Carolina has chosen and has decided it means violent force in the robbery context. It used by force and violence or by intimidation, which South Carolina, I will argue to the court or submit to the court, intimidation and coercion is used very much interchangeably in South Carolina. And coercion has been found to be a non-violent means of achieving a criminal act. And so is this case closer to United States v. Evans, or is this case closer to State v. Richardson? An appellant would argue that this case is closer to State v. Richardson, as there's nothing in this case, in this statute, that would prevent the pastor from using the same economic and moral influence that was used in Richardson here in this case with Mr. Croft. The last thing, I didn't get to finish my thought last time with regards to apparitio soria, and that's just to address my colleague's argument that there are no cases that show the carjacking impact. And in refusing the government's invitation in apparitio soria, Judge Davis said that all that's needed is that offensive physical contact, which the Court of Appeals has affirmed in Maryland for resisting arrest. Well, here's the same situation. I think what we have is force or coercion, which the state Supreme Court and State Court of Appeals has defined as being nonviolent. And so in looking at it, we don't need a cited opinion. We don't need something that's risen up on appeal, because the state Supreme Court and the state appellate court has already made the determination that force or coercion, again, is very similar to force and violence or by intimidation, includes nonviolent conduct. And to close the thread, Shropshire, which is where this Judge Thacker mentioned, or I'm sorry, maybe Judge Quattlebaum, where it mentioned the Tennessee Supreme Court looked at the pattern jury instructions. Those pattern jury instructions were the exact same as the definition of coercion in Black's Law Dictionary. And with that, that's the end of my time, and I'll ask this court to reverse the ruling of the lower court. Thank you.
Thank you very much. We appreciate the arguments of both counsel. You did really a fine job. It's hard to do at 4:30 in the afternoon. Thank you very much.
Well, they are from South Carolina, so that
Well,
they have an advantage.
That's true. And Judge Motz, I just wanted to note that I think Mr. Graves is court appointed.
I was just about to ask, are you court appointed? Well, you did. You did a great job for your.
Thank you, and thanks the court for this opportunity. This was great. Thank you.
And Ms. Stoughton did a wonderful job on behalf of the government.
She absolutely did.
Thank you, Your Honor.
All right.
Thanks.
We're waiting to have somebody separate us all.
We will, we'll have the courtroom deputy adjourn court, and then we'll place you in the robing room, Judge Motz, okay?
Perfect.
All three, thanks.
I'm still on the phone.
This honorable court stands adjourned until tomorrow morning.
If you do the wrapping,
the United States and the honorable court.
Fred, do you hear the noise?
She's still there.